welcome to my channel Kickstart Privacy. I would like to say thank you all for your support and suggestions for my first video on assessing data protection practices in the lens of data governance part 1. In this part 2 series, we are going to deep dive into how we can assess the data collection practices in an organization, identify gaps, risks, and mitigate to comply with the relevant data protection regulations. All right. Before moving on to the questionnaires, I would like to say a few words about data collection practices. What is it referred to, etc. So, data collection practices refer to the methods, protocols, and systems an organization uses to gather, store, and manage information. Right. So these practices should align with the ethical standards, legal requirements, and best practices in data management to ensure data accuracy, security, and privacy. So, in simple terms, it is the process of gathering specific relevant information to help the organizations, achieve its objectives and make informed decisions. Okay, so the data collected can be of various types. For example, operational data that is mostly related to day-to-day operations such as service interruptions, machine uptime, production rates, etc. And financial data, information about the company's financial health, like revenues, expenses, profits, and losses. And in the case of customer data, it is more about customers, their buying habits, preferences, feedback, and other information that can help in personalizing offerings and improving customer satisfaction. And one more category is employee data. This information regarding employee performance, attendance, their skills, satisfactions, and other HR related metrics, right? So there are methods and tools, for data collections in organizations, that might include surveys and questionnaires. There are tools used to gather information from a group of people. Observations, they're watching and recording actions or behaviors online or offline. Databases, comprehensive systems, that stores, organize, and manage a large set of structured data. Business intelligence tools. These are softwares that can extract, process, and analyze data to produce insights, right? And another method is point of sale systems. These are tools that captures sales and inventory data in real time. And web analytics tools. These tools that monitor and record website and app user behaviors. The next one, the feedback forms, right? The structured form. These are structured form that capture feedback from users, customers, or employees. So most importantly, data collection must be done ethically and in compliance with relevant laws and regulations, especially when it comes to personal data, right? So organizations need to transparent about what they are collecting, why they are collecting it, and how they will use it. This is to ensure data privacy and security at all times. All right. Now we move on to the part of it, data collection, how we assess the data collection practices in an organizations. But before that, these questions, these assessment questionnaires are meant to provide a general idea of the types of questions you may include in your assessment. So it is crucial to tailor them to your organization specific context, processes, and legal requirement. To accurately assess data protection practices and compliance with the relevant data protection regulations. All right. Okay, let's go to the next slide. All right. So this is the part of it, data collection, assessing data protection practices in an organization in the lens of data collection. Let's move on to the first question in this series. Okay. All these questions, you assess and answer, based on your organization's current status. Okay. So I mostly go with the answers are yes or in place perspective, and I will also explain to you why the reason or the risk if that is not in place, or if it is not assessed, or partially assessed or something. All right, I will explain to you. Okay, the first question is personal data collected only for specified, explicit, and legitimate purposes? So before you are collecting any personal data, there should be a purpose, not to link to it, right? And let's see, the options are: option A, yes, personal data is collected only for specified, explicit, and legitimate purposes. Option B, no, there is no personal data collected with clear purposes. Third option, C, some personal data is collected for specified purposes, but improvements are needed for clarity. Fourth one, option, data collection purposes have not been assessed at all. Okay, so as I said, I go with the answer yes, because we have the personal data that are collected only for specified purposes, explicit and legitimate purposes only. Okay, what is the reason if we have achieved these purposes and its data collection practices? Now, collecting personal data for specified, explicit, and legitimate purposes is a fundamental principle of data protection. Please note that it is a fundamental principle of data protection. What is that? Purpose limitation. Okay. And it ensures that individuals are aware of how their data will be used and allows them to provide informed consent. All right. Okay, now let's see what is B. That means there are no clear purposes in place. So in that case, people, the data subjects, they don't know why you are collecting their data, right? And it, of course, leading to mistrust. Okay, and what about option C? Some, having some clarity is better than nothing, right? But partial clarity can still be confusing for people, confusing for data subjects. What about option D? If you have not even checked, why you are collecting data, it's likely you are not following any best practices. Okay, and in short, knowing and clearly stating the reason for collecting personal data is essential for trust and transparency. All right, let's move on to the next question. Are individuals provided with clear and comprehensive information about the data collected from them? Right, the individuals, the data subjects should be informed of their collection of their personal data. Right. So options are A, yes, individuals are provided with the clear and comprehensive information about the collected data. Option B, no, individuals are not provided with any information about the collected data. Option C, some information is provided, but improvements are needed for clarity and comprehensiveness. Option 4, information about collected data has not been assessed. So, based on your organization's current status, as I mentioned in the beginning, so if you have clear communication about their data collection practices, maybe in the form of a privacy notice or a privacy statement to the customers, you achieve that part of it. So the reason providing clear and comprehensive information to individuals about the data collected from them is essential for transparency. Right, transparency. So basically, it's again a data privacy principle. So we are complying with it, transparency and informed consent. It enabling them to understand how their data will be used. Let's see, option B, not telling people what data you are taking from them means they are left in the dark, leading to suspicion, right? Option C, partial information can be as misleading as no information, causing confusion. And option D, if you have not checked what info you are giving to people, it's hard to ensure you are being transparent. All right, let's move on to the third question. Is personal data collected directly from the individuals except where lawful exceptions apply? Let's see what are the options available, and I will explain to you why it matters and why it doesn't matter. Option A, personal data is collected directly from the individuals except where lawful exceptions apply. Option B, no, personal data is collected from other sources without involving individuals. Option C, some personal data is collected directly, but improvements are needed for consistency. Option D, source of personal data collection has not been assessed. All right, so let's see the answers are. So I'm going to go with option A because the personal data, what we are, collecting only from the individuals directly, except where lawful exceptions apply. The reason is when you are collecting the personal data from the individual directly, it promotes transparency, it ensures accuracy, and it allows individuals to exercise their data protection rights, such as providing consent or accessing the data and etc. I will also explain when you have a B status, taking data from other sources other places, without telling the individuals, can be a deceptive and might lead to errors, right? When you are collecting data from them directly, you know what data you are collecting from them. But if you are collecting from other sources, there might be data missing, or there might be data incorrect, right? So that's the reason, always try to collect the data directly from the respective individuals. What about why? If you have a status in your organization, um, that if you are inconsistent in collecting data directly, it is hard for individuals to know what to expect, right? Option D, if you have not checked where the data comes from, it's hard to guarantee its accuracy and transparency, as I explained to you in the beginning. So in a nutshell, getting data directly from people is the most transparent and reliable method. All right. Let's move on to the next question 4. Is personal data collected limited to what is necessary and relevant for the specified purposes? What we are talking about is the data minimization practices. Okay. Let's see, the options are yes, personal data collection is limited to what is necessary and relevant. No, personal data collection includes excessive or irrelevant information. Option C, some personal data collection is limited, but improvements are needed for comprehensive compliance. Option D, limitation of personal data collection has not been assessed. So I'm going to go with the answer yes, because in our organization, we have the practice of data minimization. We are collecting the data that is necessary and relevant. Okay, so when we do that, limiting personal data collection to what is necessary and relevant is a key principle of data protection. Data minimization is one of the key principle of data protection. So it minimizes the privacy risk, it reduces the data storage and management burden, and it respects individuals' privacy rights, right? So what if your status in option B, collecting too much data, especially irrelevant information, it risks privacy breaches, and compliance, complicates data management practices. And if you choose option C, inconsistency in data collection can create confusion, right, and could lead to unnecessary data being collected. So we need to avoid that. Option D, if you don't assess how much data you are collecting, you can't be sure you are adhering to best practices, right? So in essence, it is best practice to only collect the data that is truly necessary for the task at hand. All right, let's move on to the next question, number 5. Are mechanisms in place to ensure the accuracy and quality of collected personal data? So you have collected all the data, but how do you ensure the accuracy or quality of the collected data? That is what my question is. So in your organization, it is in place. So you are there is a mechanisms to check the accuracy and quality of the collected data. You go with the option A. If not, option B, no, there are no mechanisms to ensure the accuracy and quality of collected personal data. Option C, some mechanisms exist, but improvements are needed for effectiveness and consistency. Option D, accuracy and quality of collected personal data have not been assessed. All right. The answer, yes, because we are following this, practice. We have the mechanisms in place to ensure the accuracy and quality of the collected personal data. So if you are doing that, by implementing mechanisms to ensure the accuracy and quality of collected personal data, such as data validation processes. This is one of the mechanisms, to check the accuracy. Data validation processes and regular data updates. You keep a due diligence process of regularly updating data in your organization. It helps maintain data integrity and data reliability for the intended purposes of processing. All right. So what about option B? If that is the status, without mechanisms for accuracy and quality, the data you collected can become outdated or incorrect, right? It is going to lead to poor decision making or non-compliance. What about option C? That is your status, partial, inconsistent mechanisms can leave gaps where data inaccuracies might occur, potentially, compromising its quality. Option D, if that is your status, not assessing the accuracy and the quality of data means the organization doesn't even know if their data is reliable, which can have negative implications, right? So in a nutshell, reliable and high quality data is fundamental to trustworthy and compliant data processing. All right, let's move on to the next question, number 6. Is consent obtained from individuals superior to collecting and processing their personal data? Okay, so consent is important. It's one of the lawful basis for processing personal data, but there are certain conditions for consent. I will explain to you in another video about consent. Let's see if your organization is practicing this consent as a lawful basis for processing, and it is superior to the collecting and processing of their personal data, then you can go ahead and say yes. If not, there is no requirement for obtaining consent. Option C, some instances require consent, but improvements are needed for comprehensive compliance. Option D, consent practices have not been assessed at all. Okay, and as usual, the answer I'm going to give as yes. Consent is obtained from individuals superior to collecting and processing their personal data. So if you are doing that, by obtaining individuals' consent before collecting and processing their personal data, is a key legal basis for processing under GDPR, right? It demonstrates respect for individuals' autonomy and their right to control their personal data. Let's see if your organization status as per option B, ignoring the requirement for obtaining consent can lead to non-compliance and breaches of trust, which may result in penalties and reputational damage, right? What about option C? If your organization status as per option C, while some situations might not require consent, relying on inconsistent and partial practices, might not cater to all scenarios. It's again leading to potential regulatory breaches. What about option D? If your status as per option D, if consent practices have not been assessed, there is no way to guarantee that they are compliant, right? Exposing the organization to potential regulatory and legal issues. So, in summary, obtaining proper consent is critical for respecting individuals' rights and ensuring regulatory compliance in data processing. All right, let's move on to the next question, number 7. Are special categories of personal data, maybe sensitive data, collected only with explicit consent, or where lawful exceptions apply? So, there are certain personal data are classified as special categories of data as per GDPR. Your religions data, your health data, biometric data. So likewise, there are data categorized as sensitive personal data or special categories of data, right? So, so when you are collecting such data, are there consent explicitly obtained from the individual? That is what the question. So yes, option A, the special categories of personal data are collected only with explicit consent or where lawful exceptions apply. Option B, no special categories of personal data are collected without explicit consent or lawful exceptions. And your status, some collection of special categories of personal data complies with the requirement, but improvement are still needed for consistency. Option D, collection of special categories of personal data has not been assessed yet. So if your organization following or collecting the special categories of data, with explicit consent, then you go with option A. And the reason why is that the special categories of personal data such as health information, racial or ethnic origin, these require a high level of protection, right? So that's why it's called sensitive personal data. Sensitive personal data always require a one step further of level of protection. Collecting such data only with explicit consent or where lawful exception apply ensures compliance with the GDPR's provisions on sensitive data processing. All right. And let's see if your status, as per option B, collecting sensitive data without explicit consent or without a lawful exception is a direct breach of many data protection regulations, right? You are actually risking severe penalties, and not only penalties with the regulators, and also the loss of trust with the customers, right? What about option C? If you have the status in your organization as per option C, inconsistent practices in handling sensitive data could lead to accidental breaches or misuse of such data, even if some instances comply with requirements. What about option D? Without assessing the collection practices of special categories of personal data, the organization cannot be sure of its compliance. because you don't have any practices in place, which can leave them exposed to potential regulatory risks, right? Okay, let's move on to the next question. Okay, before that, in essence, due to the heightened risk associated with the sensitive personal data, it is imperative to handle such data with the utmost care and ensure all regulatory requirements are met. All right. Let's move on to the next question, eighth question. Are data subjects informed about their right to withdraw consent at any time? And is the withdrawal process clearly explained? All right, so let's see. The options are yes, my company practices this process. Data subjects are informed about their right to withdraw consent, and the process is clearly explained. All right. And option B, no, data subjects are not informed. Data subjects are not informed about their right to withdraw consent because the consent was the originally the lawful basis for processing. So we need to give them the rights to withdraw their consent as well. Okay, that is what is talking about. Some option C, some information about the right to withdraw consent is provided, but improvements are still needed for clarity. Option D, information about the right to withdraw consent has not been assessed. So, if your organization practices, as per option A, you can go ahead and say yes. The data subjects are informed about their right to withdraw consent, and the process is clearly explained. The reason why informing them, the data subjects or the individual, about their right to withdraw consent and providing clear instructions on how to exercise that right demonstrates a respect for individuals' autonomy and their ability to control the processing of their personal data. It's a very classic example is, sending, when you are sending a promotional email to them, always keep the opt out option at the bottom of the email content. Okay, so that if they don't want to proceed with the promotional email or content, they can anytime go ahead and withdraw their consent. All right. And let's see what if your status as per option B, C, and D, not informing data subjects about their rights, hampers their ability to make informed decisions about their data. Option B, if your status is as per option C, partial or unclear information can lead to confusion and might prevent data subjects from effectively exercising their rights. Option D, without assessing information practices, regarding consent withdrawal, etc., an organization remains unaware of, potential compliance gaps or risks. So overall, proper communication about consent, withdrawal rights, and processes ensure transparency, and fosters trust between the data subjects and the organization. All right. Let's move on to the next question, number 9. Is there a process in place to handle data subject requests to access their personal data? So it may be an email ID you can provide in your privacy notice, such as privacy at the rate of company name, or a DPO at the rate of company name, so that they can exercise their rights by sending to you the emails, etc. Or you can provide them a phone number. It's up to you as per your organization practices. All right. So The options are if your organization status that is being practiced by keeping them the relevant email addresses to access or exercise their rights, then you can go ahead with option A. And there is no process to handle data subject access request. And option C, some process exists but improvements are needed for efficiency and effectiveness. Option D, handling of data subject access request has not been assessed at all. So if your organization status is as per option A, that means there is a process in place to handle data subject access request. The reason, having such a process in place to handle the request for access or any other rights to their personal data enables organizations to fulfill individuals' rights to transparency and control over their data. All right. What about option B, C, and D if your organization facing such status? Option B, without a process, organizations can't effectively respond to data subject request, right? Which can lead to non-compliance and distrust. Option D, and an incomplete or inefficient process may result in delays or errors in providing data subjects with their data, because there are data subject rights that needs to be fulfilled within 30 business days or something. Okay, so if you have an inconsistent process, that may result in delays or error in providing data subjects with their data. All right, so option D, if organization have not assessed their handling of access request, they might be unaware of potential issues or gaps in compliance. So overall, being prepared to address access request, demonstrates an organization's commitment to upholding individuals' data rights. Let's move on to the next question, the last one, the 10th one. Our data subject provided with information about the retention period for their personal data. Retention period, right? How long we are going to keep the data or store the data, delete the data, etc. So the options are, if your organization have a proper retention period for deleting, keeping the personal data, you can go ahead and say yes, data subjects are provided with information about the retention period for their personal data. Option B, no data subjects are not informed about the retention period. Option C, some information about retention period is provided, but improvements are still needed for clarity and comprehensiveness. Option D, information about the retention period has not been assessed. So you go ahead and go say yes if you are if you have a retention period that is implemented in your organization. Okay, the reason is informing data subjects about the retention period for their personal data ensures again transparency, okay, and enables individuals to understand how long their data will be stored and the purposes for which it will be retained. All right. In case if your organization status as per option B, without informing data subjects about the retention period, organizations risk non-compliance and may create mistrust among data subjects. What about option C? Partial information can be always confusing, right? and may not give a complete picture to data subjects about how their data is managed. Option D, um, if the retention period has not been assessed at all, you don't have a retention period in your organization, for keeping their data, personal data, their potential for data being held longer than necessary, increasing risks and potential non-compliance. So we are talking about a storage limitation here. You keep the data as long as it is necessary. That is what it is all about. So overall, clarity about retention periods helps organization maintain good data hygiene practices and uphold the principles of data minimization. All right. I think that's it for today. Um, Thank you so much for watching it again. Uh, if you like it, please hit the button like. If you have any comments to share, just please comment, and also share it to the relevant people. All right. Keep watching it for the rest of the topics. I am actually working on it. That is going to really make sense on how to assess the privacy protection practices in an organization. All right. Thank you so much again. Bye bye.